Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, listen, there has been a lot of tumultuous activity in the 2A community over the last few months, whether we're talking about forced reset triggers, solvent traps, wide open triggers, pistol stabilizing braces, magazine bans, appellate cases. It seems like there is constantly new news, occasionally good, oftentimes bad. But let us not forget that over the summer, the ATF published a new rule on frames and receivers, and that has a lot of us puzzled as to what does this really mean to us. Now, in addition to that, there's been a lot of confusion on the retail side as to what can be sold, what can't be sold, what really is an unfinished frame or receiver, what needs to be serialized. I'm happy to say I got some information hot off the presses from our good friends in the FFL industry. So today, we're going to have to spend a few minutes and talk about what does ATF consider an AR frame or receiver to be today? Okay, so the issue we're talking about today is an open letter from ATF to FFLs. Where did I get this information? Well, I got it from my good friends at Security Gun Club, who happens to be sponsoring today's video. You see, Security Gun Club is by far the nicest indoor facility you will find anywhere in the state of Washington. The only thing better than the facility, well, that's two things. Number one, they have absolutely the nicest, most professional staff anywhere in the business. Stop by, say hi, tell them I sent you. More importantly than that, it's security's dedication to education. You see, Jackson, head of training over there, has developed an amazing curriculum that will cater to anybody of any skill level at any need. So whether you're brand new to firearms or you've been around guns your whole life, they have training that you will need. Listen, you need to practice to stay out of the morgue. You also need to practice to stay out of prison. So stop by, do one of their basic self-defense law classes. Stop by, yours truly, once a month at Security Gun Club. So for more information, visit them at securitygunclub.com. Now, that is not a misprint. That is security with an E. So visit them at securitygunclub.com. Okay, so the issue, like I said, we were talking about is this open letter that was just sent to FFLs from ATF. It is a letter that is meant to help clarify what constitutes a frame and receiver, what is really an unfinished frame or receiver, what we call 80% lowers, what can be sold without serialization, what needs to be serialized, and people need to go through a 4473. And I've gotten a lot of questions on this issue because I know a lot of online retailers are still trying to figure it out, and candidly, I think a few of them are probably getting very close to the edge. The open letter starts off by stating, the Bureau of Alcohol, Tobacco, and Firearms is issuing this open letter to further assist the firearms industry and the public in understanding whether a partially complete, disassembled, or non-functional receiver of an AR-15 M16 variant weapon has reached the stage of manufacture such that it may be readily completed, assembled, restored, or otherwise converted to a functional receiver and is therefore classified as a frame or receiver or firearm in accordance with the final rule titled Definition of Frame or Receiver and Identification of Firearms, or what we call Final Rule 2021R-05F, which of course became effective August 24th, 2022. So this letter, just so we're clear here, is limiting to 80% lowers, unfinished frames and receivers for the AR platform. These right here, okay? I know there's a lot of questions about other types of frames and receivers, and as we learn the answer to those, we will be doing more videos on them, but right now this deals with any unfinished frame or receiver for an AR platform firearm. Now, the ATF further states, as stated in Final Rule 2021-05F and the regulatory text, a partially complete AR-type receiver with no indexing or machining of any kind performed in the area of the fire control cavity is not classified as a frame or receiver or firearm, provided that it is not sold, distributed, or marketed with any associated templates, jigs, molds, equipment, tools, instructions, or guides, such as within a receiver parts kit. So, if the frame has no machining or indexing in the fire control cavity and does not have any jigs or other molds or instructions or anything else that assists the person in completing the frame or receiver, then there is a chance, according to the ATF, so you're saying there's a chance that this might actually still be a chunk of aluminum. But the ATF, always the givers that they are, gave us some specific examples. Now, this is how they explained it in the open letter. Consistent with Final Rule 2021 R-05F and the regulatory text, ATF is providing the visual aids below to further illustrate the section of an unfinished item that, with further manufacture, machining, or processing, will constitute the fire control cavity. The second set of visual aids illustrates the stage of manufacturing machining at which the item becomes a receiver as defined in Final Rule 2021 R-05F. Now, one of the very first examples they give here is this one right here. And what ATF says about that is a partially complete AR-type receiver with no indexing or machining of any kind performed in the area of the fire control cavity is not classified as a receiver or firearm if not sold, distributed, or marketed with any associated templates, jigs, and so forth. So as you can see here, there are no holes or dimples for the selector, the trigger, the hammer pins, anything of that. So according to ATF, that is not a firearm. And again, they give us this example right here, which of course says because there is no trigger slot as they define it, then this, again, as long as it's not sold with any jigs, templates, or anything like that, would not constitute a firearm. Okay, now this is really important. This is getting into some of the fine detail, but when we are talking about the level of machining that must be done prior to receiving it before, is it a frame or receiver, or is it still just a chunk of aluminum? And I know this is kind of ridiculous that we're having to have this conversation, but it's 2022 and this is the world we live in. But when you take a look at this example right here, you can see that in order to preclude classification as a firearm, this area of the receiver, in addition to being solid, must not contain any holes or dimples for the trigger, hammer, and selector. So if we have dimples in these areas, or if we have markings to show where the machining needs to take place, now we probably crossed that magical threshold from chunk of aluminum to frame or receiver, now regulated by a 4473. Now, the ATF also gave us some examples of what does constitute a frame or receiver. So according to ATF, these items have already reached the stage of manufacture such that they are now classified as frames or receivers, would need to be serialized, and in order to purchase that, you would need to fill out a 4473 and then go through whatever system your state has in place for the purchase of a firearm, because these now are defined as, in and of themselves, a firearm. Okay? Now, taking a look at some of ATF's examples, such as this one right here, we can see that their holes have already been drilled out for the selector, the trigger, and the hammer pin. And so in that situation, ATF right there, that's a frame or receiver. Now, when we look at this second example right here, we can see that the trigger slot has been milled out and created, and therefore the ATF would say, hey, that too constitutes a fully finished frame or receiver subject to ATF regulation. And then the third example, this one right here, shows us that just the mere milling out of the selector hole alone, so it's not milling out all three of them, it's milling out any one of those three, will convert that thing from a chunk of aluminum to, in the eyes of the ATF, again, this is not my opinion, okay? This is what the ATF is saying. It goes from chunk of aluminum to federally regulated firearm at that point. Now, if we want to really digest the big, huge word salad that ATF wrote, this is how they are justifying this legally. Under 27 CFR 478.12, the terms frame and receiver shall include a partially complete, disassembled, or non-functional frame or receiver, including a frame or receiver parts kit that is designed to or may be readily be completed, assembled, restored, or otherwise converted to function as a frame or receiver, i.e. to house or provide a structure for the primary energized component of a handgun, breech blocking or sealing component of a projectile weapon other than a handgun, or the internal sound reduction component of a firearm muffler or firearm silencer, as the case may be. Because we all know that suppressors standing alone constitute firearms. The regulation further states, the term shall not include a forging, casting, printing, extrusion, unmachined body, or similar article that has not yet reached the stage of manufacture where it is clearly identifiable as an unfinished component part of a weapon. When issuing a classification, the director may consider any associated templates, jigs, molds, equipment, tools, instructions, guides, or marketing materials that are sold, distributed, or possessed with the item or kit or otherwise made available by the seller or distributor of the item or kit to the purchaser or recipient of the item or kit. And at least the ATF does not write redundant sentences, okay? Now, when they're talking about what do they look like, what are they going to be looking at to determine how readily available or how readily can this be converted? There are several criteria that the ATF is going to look at. According to them, they include the following. 478.11 and 479.11 define readily as a process, action, or physical state that is fairly or reasonably efficient, quick, and easy, but not necessarily the most efficient, speediest, or easiest process, action, or physical state. With respect to the classification of firearms, factors relevant in making this determination include the following. A, time. How long did it take to finish the process? B, ease. How difficult is it to do so? C, expertise. What knowledge and skills are required? D, equipment. What tools are required? E, parts availability. Whether additional parts are required and how easily can they be obtained? F, expense, i.e., how much does it cost? G, scope, the extent to which the subject of the process must be changed to finish it. And H, feasibility, whether the process would damage or destroy the subject of the process or cause it to malfunction. Okay, so as you can see, there's this spectrum that the ATF is using. Where are we in the stage of manufacturing, and then how easy is it to get this product over the magical finish line where we go from raw product of aluminum to suddenly federally regulated firearm? Now listen, these rules are developed by the ATF, and the ATF presumably understands firearms, but that is debatable. But let me show you what a couple of the problems is with this and how they're really not going to solve any problem if there is a problem to be solved anyways. According to the ATF's own regulations, this is how they are viewing as it relates to people who are selling these kits. When issuing a classification, the director may consider any associated templates, jigs, molds, equipment, tools, instructions, guides, or marketing materials that are sold, distributed, or possessed with the item or kit, or otherwise made available by the seller or distributor of the item or kit to the purchaser or recipient. Now, I am not encouraging anybody to do this, but I am a lawyer and we dissect the English language on a daily basis. And as I see this, the way this regulation is written, if Company A is selling unfinished frames or receivers that are at such a stage of manufacture that they are nothing more than a chunk of aluminum, and Company B that has no relationship to Company A whatsoever is selling jigs and templates and drill bits and instructions for a product that they do not sell as far as what would be remanufactured, are either of those two companies in violation of these new federal rules? There is nothing in this rulemaking that would allow the manufacturers of these 80% lowers to begin labeling them with standard labels so that secondary manufacturers can produce all the jigs and templates necessary, and they would be matched up by the same numerical or alphabetical code given on the unfinished frame or receiver. Under these rules, there is absolutely nothing unlawful about that. And I say that because even though one part of it clearly defines readily, and we look at the criteria such as how easily can we obtain it, the other part of this rule specifically says that the director is to look at any jigs and templates and other equipment that is sold with the part or sold by the same company that sold the part. Listen, as we begin to dissect this more and figure this more out, we will do more videos. And let us remember that starting next month, we are doing a series of videos with an FFL called Ask an FFL, where we're going to be able to get into some real specifics about unfinished frames and receivers, 80% lowers, pistol braces, Form 4999, Form 1s, Form 4s. We'll have it all for you. In the meantime, if you have any other questions about this stuff or anything else related to your Second Amendment rights, remember you can always contact us at WashingtonGunLaw.com, or you call us directly at 425-765-0487. Now, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. and stay safe.